Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking, your go-to source for insightful discussions on all things related to criminal law. It's brought to you by Aitken Robertson Criminal Law. I'm Melanie van Orde, your host, and today we have a very special topic on the agenda, peace bonds. Joining me is counsel Dan Lemaire, an esteemed criminal lawyer at Aitken Robertson. Together, we'll be diving into the intricacies of a peace bond, exploring what they are, how they work, and their significance in the legal landscape. So whether you're seeking clarity on peace bonds or simply interested in staying informed about the latest developments in criminal law, you're at the right place. Stay tuned for enlightening discussion that promises to unravel the complexities of peace bonds. Dan, can you explain what exactly is a peace bond and how does it differ from the legal measures?
Certainly. So a peace bond is something that as a defense counsel, we are often trying to achieve in a case. This is particularly useful in domestic violence cases, charges of that nature, perhaps a neighbor dispute even. A peace bond is important because it is not an admission of guilt, and it is often a middle ground between the Crown's interest and the defense interest that allows us to resolve the case without you entering a guilty plea and while still protecting your long-term interests and particularly your criminal record.
And then what's the difference between a common law peace bond and a Section 810 peace bond?
The difference really is that a Section 810 peace bond is something that is ordered under Section 810 of the Criminal Code. A common law peace bond, on the other hand, is simply where counsel asks the court to exercise their own what's called common law power, basically the court's inherent power to just order the person into a peace bond.
In your experience, what are the typical conditions or terms associated with a peace bond?
Typically with a peace bond, you are going to be looking at a 12-month duration. There will be terms to keep the peace and be of good behavior. There may be terms that you are to have restricted communication with someone, perhaps a complainant. We can often work in exceptions to that if it's a domestic situation and those exceptions are desired. And there may be terms as well that you not possess any weapons as defined by the criminal code.
And then what happens if someone breaches the conditions of a peace bond?
So breaching a peace bond is actually a serious offense because you are breaching a court order. So if you are found to have breached the peace bond, you could be facing actually some jail time. You might also have to forfeit a monetary amount, typically $500 or $1,000.
Are there any potential consequences or limitations for a person who agrees to enter into a peace bond?
Yes, there are some things that you will want to discuss with your lawyer before entering into a peace bond. A peace bond could have an effect on family court in particular. So if you are in a domestic situation, even though you are not admitting any civil or criminal liability in the criminal court, the family court will treat that peace bond quite differently. And so it's something that you really want to discuss with your family lawyer before you enter into.
And then will a peace bond come up on a police check or a vulnerable sector check?
So there are different levels of police record checks that you may be having to get for employment or volunteering or things of that nature. The type of record check that's required is really going to dictate whether that peace bond shows up. For 12 months, while the peace bond is active, the peace bond will show up on the two deepest levels of record check, but it shouldn't show up on a basic record check, the first stage, so to speak. After 12 months, the peace bond should not be showing up on any record check at all. However, there are often issues with police stations retaining those records and still disclosing them after 12 months. So it's something that we need to be alive to even after the 12-month period expires.
Thank you so much for all that information, Dan. And thank you for everyone else for joining us today on the Legally Speaking Aiken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aiken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.